"Sir, you need to leave the building right now. This is my office. I don't care whose office you claim it is. I've never seen you before, and you're not on my list. My name is on the lease. I'm one of the founding partners. Sure you are. Turn around and walk to the door, or I'm calling the police. Go ahead and call them. I'd like them to see this too." The lobby security camera captured all of it in high definition, time-stamped, unbroken, impossible to argue with later. And security guard Wesley Grant had no idea that the man he had just physically escorted out of a downtown law firm on a Monday morning was not only a founding partner of that firm, but a sitting judge on the United States Court of Appeals, a man whose signature on a legal opinion could reshape federal law across 3 states. Within 6 weeks, that mistake would cost Wesley his job, cost the security company its multi-million-dollar contract, and cost the building's management firm nearly $3 million in a settlement that made national headlines. Before we get into this one, drop a comment and tell me where you're watching from, and if stories about power, assumption, and consequences matter to you, hit that subscribe button right now, because this story only gets more unbelievable the further in we go. Judge Marcus Ellison was 51 years old and had spent the last 7 years on the bench of the United States Court of Appeals for the 6th Circuit, one of 13 appellate courts in the entire federal system, and one of only a small handful of judges in the country whose rulings could set binding precedent across multiple states at once. Before his appointment to the federal bench, Marcus had spent 19 years building one of the most respected litigation practices in Cincinnati, Ohio, co-founding a law firm that bore his name on the letterhead long before he ever put on a robe. Ellison, Park, and Whitcomb had started small, 3 attorneys and a receptionist, working out of a modest suite on the 4th floor of an aging office building. Over 2 decades, it had grown into a firm with 60 attorneys spread across 3 floors of a gleaming downtown tower, a firm that handled complex federal litigation, appellate work, and constitutional challenges that regularly made their way through the same court system Marcus now presided over from the bench. When Marcus had been nominated and confirmed to the federal judiciary, he had stepped back from active litigation, as ethics rules required, but he had never fully stepped away from the firm itself. He remained a name partner, held a seat on the firm's advisory board, and kept a small office on the 40th floor that he used whenever he was in the building for advisory meetings, mentoring younger associates, or simply catching up with the partners who had built the practice alongside him for 2 decades. That Monday morning, Marcus had a 9 o'clock meeting scheduled with the firm's managing partner, a longtime friend and colleague named Diane Whitcomb, to discuss a mentorship program the firm was launching for first-generation law students. He had dressed casually for the meeting, khakis and a button-down shirt without a tie, comfortable clothing appropriate for what he expected to be a relaxed internal conversation rather than a formal court appearance. He drove himself downtown, parked in the garage he had used for over 15 years, and walked into the lobby of the building that bore, in brushed steel letters above the security desk, the very name of the firm he had helped build from nothing. Nothing about that morning suggested anything unusual was about to happen. Marcus had walked through that lobby thousands of times across 2 decades. He knew the building superintendent by name. He knew which elevator bank ran fastest during the morning rush. He had celebrated firm anniversaries in the lobby atrium, had walked incoming summer associates through orientation tours that started at that very security desk. But on this particular morning, the regular daytime security guard was out sick, and the company that held the building's security contract had sent a temporary replacement who had never worked this location before and had received almost no orientation beyond a photocopied tenant directory and a badge scanner he barely understood. Wesley Grant was 28 years old and had been working private security for just under 3 years, most of it at retail locations and low-security commercial buildings, where the stakes of a mistake were measured in shoplifting incidents rather than anything resembling this. He had been assigned to this downtown tower that morning, with less than 2 hours' notice, handed a laminated sheet listing tenant names by floor, and told to check identification for anyone who didn't have a building access badge already programmed into the turnstile system. Marcus, who almost never needed to use his badge because the regular guards simply recognized him and waved him through, did not have his badge with him that morning. It was sitting in a drawer at his chambers across town, a small detail that would matter enormously in the next 4 minutes. Have you ever been stopped somewhere you had every right to be, just because someone new didn't recognize you? Drop a yes or no below, because what happens next will make you furious. Marcus approached the turnstile, nodded a casual good morning to Wesley without really looking at him closely, the way anyone does with a familiar routine, and reached for the badge reader before realizing his access card wasn't in his pocket. No problem, he thought. He would simply give his name. "Morning," he said. "I don't have my badge on me today. Marcus Ellison, 40th floor, Ellison Park and Whitcomb." Wesley scanned the laminated directory sheet in his hand, running his finger down a list of names that, due to a printing error from the property management office weeks earlier, had failed to include several of the firm's senior partners, Marcus among them. The sheet had been generated from an outdated tenant roster that predated Marcus's most recent office reassignment within the firm's internal floor plan, a bureaucratic mistake that had nothing to do with Wesley personally, but everything to do with what happened next. "I don't see that name here, sir," Wesley said. "Do you have any other identification?" Marcus, still not registering any real concern, reached for his wallet and produced his driver's license. "This is my office," he said, his tone still light, still patient. "I'm one of the founding partners of the firm. I've worked in this building for over 20 years. Wesley looked at the license, looked back at his sheet, and made a decision that would define the rest of the morning. "Sir, I don't have you listed as an approved tenant, and I can't let you through without verification from the building or the firm itself." Marcus's patience, still largely intact, began to thin slightly. "Then call up to the 40th floor and ask for Diane Whitcomb," he said. "She'll confirm exactly who I am in about 10 seconds. This is precisely the moment where a competent, properly trained security officer would have made a call, verified in under a minute, and moved on with the day without incident. Instead, Wesley made a different choice, one shaped less by protocol and more by an instinct he had developed over years of retail security work, where the vast majority of people who pushed back against being stopped turned out to have something to hide. "I need you to step to the side, sir, while I sort this out," Wesley said, and his hand moved toward the radio clipped to his shoulder in a way that signaled he had already decided how this encounter was going to go. Marcus, for the first time, felt something shift in his stomach, a familiar, weary recognition of a pattern he had encountered more times across his 51 years than he could easily count, despite every credential, every accomplishment, every hard-won achievement standing behind him. "I don't need to step to the side," Marcus said, his voice steady but firm now. "I need you to make one phone call to verify what I've already told you. That's not an unreasonable request." Wesley's expression hardened. "Sir, this is my office. I don't care whose office you claim it is," he said. "I've never seen you before, and you're not on my list. My name is on the lease," Marcus said. "I'm one of the founding partners." "Sure you are," Wesley said, and the sarcasm in his voice carried a weight that had nothing to do with genuine security procedure and everything to do with disbelief that this particular man, standing in front of him in khakis and no tie, could possibly be telling the truth. "Turn around and walk to the door, or I'm calling the police." "Go ahead and call them," Marcus said. "I'd like them to see this too." What happened over the next 90 seconds would be captured from 3 separate camera angles positioned throughout the lobby, footage that would later be pieced together, frame by frame, by attorneys, journalists, and eventually a federal judge, presiding over the very lawsuit that this moment would spawn. Wesley grabbed Marcus by the upper arm, not violently, but with clear physical intention, and began guiding him toward the revolving doors at the building's entrance. Marcus did not resist physically, understanding instinctively that resisting a security guard's physical contact, however unwarranted, in a lobby full of witnesses and cameras, was a far more dangerous choice than simply allowing himself to be walked outside while he continued speaking calmly. "I am telling you clearly and for the record," Marcus said as Wesley walked him toward the exit, "that I am a founding partner of this firm, and that you are currently making a mistake that is being recorded on at least 3 cameras I can see from here." Wesley didn't respond. He pushed the revolving door open and guided Marcus through it, out onto the sidewalk, in front of a Monday morning crowd of pedestrians, delivery workers, and office employees streaming toward their own buildings. Should security personnel be legally required to verify a claim before using physical force to remove someone from a building? Let me know what you think in the comments below. A young paralegal from the firm, a woman named Rachel Okonkwo who had started at Ellison Park and Whitcomb less than a year earlier, happened to be walking into the building at that exact moment and recognized Marcus immediately, having sat across from him during her own final round interview 8 months prior. "Judge Ellison," she said, stopping in her tracks, her voice carrying genuine alarm. "What's going on?" Wesley froze. "Judge," he repeated, the word landing with a weight that visibly registered on his face. Rachel didn't wait for an explanation. She pulled out her phone and immediately called up to the 40th floor, reaching the firm's receptionist within seconds, and relaying, in a rapid, urgent tone, that security had just physically removed Judge Ellison from the lobby. Within 90 seconds, 3 senior partners were already moving toward the elevator bank. Marcus, standing on the sidewalk in his khakis, remained composed, though the exhaustion of the moment was visible on his face in a way that had nothing to do with physical exertion and everything to do with a familiar, corrosive fatigue that comes from having to justify your own presence in a place you helped build from the ground up. Wesley, meanwhile, stood near the revolving door, his radio still in hand, the reality of what Rachel had just said beginning to settle over him with visible weight. Diane Whitcomb, the firm's managing partner, came down personally within 4 minutes, moving through the lobby with the particular urgency of someone who understands exactly how badly something has just gone wrong. "Marcus," she said, stepping through the revolving door onto the sidewalk, "I am so sorry. What happened?" Marcus recounted the exchange calmly, methodically, the same way he approached every legal question that crossed his bench, laying out facts in careful, chronological order, without embellishment or exaggeration, because he understood that the footage would speak for itself, and that his job now was simply to ensure nothing was mischaracterized in the confusion that was about to follow. Diane turned to Wesley, her expression unreadable in the way that experienced litigators learn to control even in moments of genuine fury. "Do you understand who that man is?" she asked. Wesley's voice was smaller now than it had been minutes earlier. "He said he was a judge," he said. "He is a judge," Diane said. "A federal appeals court judge, and a founding partner of this firm whose name is on the building directory outside this lobby in letters 2 feet tall. You just physically removed him from his own building, in front of witnesses and cameras. The building's property management office was notified within the hour, and by that afternoon the security contracting company that employed Wesley had launched its own internal review, aware immediately that this incident carried consequences far beyond an ordinary customer service complaint. The firm's own general counsel, an attorney with 3 decades of experience handling exactly this kind of institutional crisis, began collecting the security footage from all 3 camera angles before end of day, understanding that preservation of evidence needed to happen immediately, before any possibility existed that footage could be lost, overwritten, or conveniently misplaced. Marcus, for his part, did something that surprised many of his colleagues, though it fit entirely within the character they had come to know across 2 decades of working alongside him. Rather than demanding immediate termination or filing suit within days, he asked for a meeting with the security company's regional manager, along with Wesley himself, to understand exactly what training protocols had failed and why an outdated tenant directory had been allowed to circulate for weeks without correction. That meeting took place 4 days later in a conference room on the 40th floor with a view stretching out across the Cincinnati skyline. Wesley arrived visibly nervous, accompanied by his regional supervisor, a woman named Patricia Suarez, who had been with the security company for over a decade and understood immediately, upon reviewing the footage the night before, exactly how serious this situation had become. Marcus opened the meeting not with anger, but with a question. "Walk me through what training you received before your shift that morning," he said. Wesley explained, haltingly, that he had received almost no site-specific orientation, that the directory sheet he had been handed was outdated, and that his standard training across 3 years of private security work had emphasized treating any pushback from an unrecognized individual as a potential red flag rather than a routine clarification request. "That is exactly the problem," Marcus said, and for the first time his voice carried an edge that revealed the depth of what he had actually felt during those 90 seconds on the sidewalk, an edge that had nothing to do with wounded ego and everything to do with 2 decades of research, litigation, and testimony he had personally conducted on the subject of implicit bias within institutional systems. "You were trained to treat resistance as suspicion, rather than trained to verify claims before acting on assumption, and in my case, the assumption that formed in your mind the moment you saw me happened before I said a single word." Patricia Suarez, understanding the legal exposure her company now faced, offered an immediate apology on behalf of the firm and proposed a series of remedial measures, additional training, updated directory protocols, a formal review of every guard assignment across their entire portfolio of buildings. Marcus listened, took notes in the careful, methodical way he approached every matter that crossed his desk, and then said something that would later be quoted in nearly every news article covering the incident once it eventually became public. "I'm not interested in punishing one 28-year-old security guard who was handed an outdated sheet and told to enforce it," he said. "I'm interested in understanding why the system around him made it so easy for him to assume, within seconds, that a black man in casual clothes couldn't possibly be a name partner and a federal judge, while giving him almost no framework for verifying that assumption before acting on it with physical force." That statement, delivered calmly in a conference room to an audience of exactly 4 people, would not stay contained to that room for long. Within 2 weeks, a version of the story had leaked, likely through someone in the firm's own support staff who had witnessed the incident secondhand, and local news outlets picked it up almost immediately. Federal appeals judge physically removed from his own law firm by mistaken security guard became a headline that traveled far beyond Cincinnati within days. What's your reaction to learning that even a sitting federal judge isn't immune to this kind of assumption? Drop your thoughts below, because the fallout that followed was more extensive than almost anyone anticipated. The building's property management company, facing mounting public pressure and increasingly pointed questions from local journalists about how an outdated tenant directory had circulated for weeks without correction, launched its own internal audit. That audit revealed that the directory error wasn't an isolated clerical mistake, but part of a broader pattern of neglected building operations, several other tenant complaints about inconsistent security enforcement, and a security contracting relationship that had been repeatedly flagged internally for inadequate site-specific training across multiple downtown properties, not just this one building. The security company terminated Wesley's temporary assignment within the week, though it stopped short of firing him outright, instead reassigning him to a different property with a formal mandate for additional supervised training, a decision Marcus himself had specifically advocated for during that initial conference room meeting, arguing that Wesley represented a symptom of institutional failure rather than the sole source of it. The company's leadership, less inclined toward nuance once the media attention intensified, and once the property management firm began signaling it might terminate the entire security contract, eventually parted ways with Wesley 3 months later during a broader restructuring that swept up several employees connected to properties under increased scrutiny. Marcus filed no personal lawsuit against Wesley individually, choosing instead, alongside the firm's leadership, to pursue a claim against the building's property management company and its security contracting vendor, arguing that systemic negligence in training, directory maintenance, and oversight had directly enabled a discriminatory incident that could easily have escalated into something far more dangerous than a 90-second sidewalk confrontation. The lawsuit detailed negligent training practices, failure to maintain accurate tenant records despite repeated internal complaints predating the incident, and a broader claim that the security company's use of force protocols disproportionately encouraged physical intervention in ambiguous situations involving black tenants and visitors across its portfolio of downtown properties. The property management company's insurance carriers reviewed the footage, the internal audit findings, and the pattern of prior complaints, and reached the same conclusion that risk management teams across the country tend to reach once video evidence this unambiguous exists. There was no viable path to trial that wouldn't result in a public relations disaster layered on top of an almost certain loss. Settlement negotiations began within 4 months. The case settled 10 months after the incident. The property management company and the security contracting firm jointly agreed to pay $2,900,000, a figure that accounted not only for the personal humiliation Marcus experienced, but for the firm's own reputational costs and the broader institutional failures the litigation had exposed. Marcus, in a decision consistent with the character he had shown throughout the entire ordeal, directed the majority of the settlement toward funding a nationwide security industry training initiative focused specifically on de-escalation and identity verification protocols, a program that within 2 years had been adopted by security contracting firms managing office buildings in over a dozen major American cities. "I don't need this money," he told a reporter during one of the only public interviews he gave about the incident. "What I need is for the next black man who walks into a building he owns, or built, or has every legal right to be standing inside, to not have to prove his own existence to a stranger holding an outdated sheet of paper. I need the systems that create these moments to change, not just the individuals caught inside them." The property management company implemented sweeping reforms across its entire portfolio in the aftermath of the settlement. Every building under its management adopted a real-time digital tenant directory that automatically updated whenever floor assignments changed, eliminating the printed sheets that had caused the initial error. Security guards received mandatory identity verification training, emphasizing phone confirmation before physical intervention in any ambiguous case, along with specific de-escalation modules addressing implicit bias in split-second assessments of who does and doesn't appear to belong in a professional space. Do you think $2.9 million was enough, given the broader systemic issues this case exposed? Let me know what you think in the comments. Judge Marcus Ellison continued serving on the Sixth Circuit bench in the years that followed, and colleagues who worked with him during that period noted that the incident, rather than souring him on his role at the firm he had helped build, seemed to sharpen his focus on institutional accountability in ways that extended into his judicial work as well. Several attorneys who argued cases before him in the following years observed that he had become notably more attentive to questions of institutional negligence and systemic bias in cases touching on employment discrimination and civil rights, drawing on his own experience in ways he rarely made explicit from the bench, but that colleagues could clearly recognize. In a rare public lecture given at a law school nearly 2 years after the incident, Marcus reflected on what had happened with the same careful precision he brought to every legal opinion he authored. "What happened to me in that lobby wasn't about one bad security guard having one bad morning," he said. "It was about a system that trained him to see resistance as suspicion rather than as a request for basic verification, and it was about the fact that no amount of accomplishment, no title, no name on a building directory fully insulates you from that split-second assumption. I've spent my career studying how institutions fail the people inside them. I never expected to become a case study in my own research, standing on a sidewalk in khakis, being told to walk to the door." He paused and continued. "But that's exactly why accountability in cases like this can't just be about punishing the individual standing in front of you when the cameras start rolling. It has to be about asking why the system made that split-second failure so easy to reach in the first place, and then building something that makes it harder to reach next time." The security footage from that morning, all 3 angles, has since become something of an unofficial training resource, quietly circulated among corporate security firms and referenced in continuing education seminars focused on workplace bias and de-escalation. Instructors point to the exact moment Wesley chose physical removal over a single phone call as the precise decision point where an entirely avoidable misunderstanding transformed into a multi-million-dollar institutional failure with consequences that rippled far beyond one lobby, one guard, and one Monday morning. What's your biggest takeaway from everything you just watched unfold? Drop it in the comments below, because I read every single one. This story matters for reasons that extend well beyond one settlement or one policy change at one property management company. Marcus Ellison had every conceivable advantage a person could hope to carry into a moment like that one. He had built the firm with his own hands over 2 decades. He held a lifetime federal judicial appointment. He had the resources, the institutional standing, and the calm, methodical temperament to navigate the confrontation without it turning physically dangerous, and to pursue accountability afterward with the same careful precision he brought to every case that crossed his bench. And he still ended up standing on a sidewalk in his own khakis, being physically walked out of a building with his own name on the lease, because a stranger looked at him for less than 3 seconds and decided, without a shred of actual evidence, exactly who he couldn't possibly be. Think about everyone who walks into buildings every single day without any of those advantages. Everyone who doesn't carry a federal judgeship in their back pocket to eventually force accountability. Everyone whose name isn't already on the building directory in 2-foot brushed steel letters. Marcus's case ended in institutional reform because every piece of the situation happened to align in a way that made ignoring it impossible. Most cases like this never get that alignment, and that gap is exactly what reform inside these systems is supposed to close. Not every wrongful removal ends in a settlement. Not every outdated directory sheet gets corrected before it causes real harm to someone standing in the lobby it was meant to protect. But this one did, and the training reforms that followed, imperfect as they remain, exist because one judge refused to let the story end quietly as an internal incident report that nobody outside 4 walls would ever read. There's one more detail from this case that rarely makes it into the shorter versions of this story, and it's worth sitting with for a moment. 6 months after the settlement, Rachel Okonkwo, the young paralegal who had recognized Marcus on the sidewalk and made the call that brought 3 senior partners downstairs within minutes, was promoted ahead of schedule and given a formal commendation from the firm's executive committee. Marcus insisted on presenting it to her personally, in front of the firm's entire staff, gathered in the 40th floor conference room where he had once sat across the table from Wesley and Patricia Suarez. He told Rachel that her decision to trust what she saw with her own eyes, rather than assuming the security guard's version of events, was automatically correct, simply because he wore a uniform and carried a radio, was exactly the kind of instinct that made accountability possible in the first place. Most people, he said, would have kept walking. She didn't. He also made a point, during that same gathering, of addressing something that several younger associates had privately raised with him in the weeks following the incident, a quiet anxiety about whether speaking up in similarly ambiguous moments might cost them professionally rather than protect them. Marcus told them plainly that the firm's culture, going forward, would treat exactly that kind of intervention as a demonstration of judgment worth rewarding, not a liability worth punishing. Several associates later described that moment as more meaningful to the firm's internal culture than the settlement itself, because it reframed an isolated incident of humiliation into a lasting institutional value. Wesley Grant, for his part, never worked in commercial building security again after his reassignment fell through during the company's later restructuring. He eventually found stable employment in a different field entirely, and according to people who worked alongside him during his final months with the security company, he carried the incident with him longer than almost anyone else involved, telling colleagues on more than one occasion that the conference room conversation with Marcus had changed how he thought about the job long before it ever cost him his position. Whether that reflection came too late to matter for his own career is a separate question from whether it mattered at all. and it's one the story leaves genuinely open rather than resolved with a tidy bow. What do you think happens to guards like Wesley once the cameras stop rolling and the settlement checks get signed? Are they simply discarded by the same systems that failed to train them properly in the first place? Or does accountability require holding both the individual and the institution responsible at the same time? Drop your take in the comments below, because this is exactly the kind of question that determines whether reform actually sticks or quietly fades once the news cycle moves on to the next headline. Thank you for watching this story all the way through. If this made you think differently about how quickly a split-second assumption can spiral into something far larger, and about what real accountability actually requires from the systems around us, share it with someone who needs to see it. Hit that subscribe button if you haven't already, because we're going to keep telling stories like this one, the ones that matter, the ones that force institutions to actually confront the gaps hiding inside their own procedures. Drop a comment. Do you think $2.9 million was enough? What would real accountability look like in a case like this? See you in the next one.